Constitutional law. First Amendment. The First Amendment protects the right to freedom of speech and press. Regulations that infringe on this right are often unconstitutional unless they fall into a category of speech that the government can regulate, i.e., false commercial speech, fighting words, obscenity, etc., or survive strict scrutiny. The government can show that the regulation is necessary to achieve a compelling state purpose. The government can regulate the conduct associated with speech with reasonable time, place, and manner restrictions. If the restriction applies in a public forum or a designated public forum, to be valid, the restriction must be content neutral and substantially related to an important government interest. If the restriction applies in a non-public forum or a limited public forum, to be valid, it must be viewpoint neutral and reasonably related to a legitimate government interest. In addition to regulation of conduct, the government can regulate content. However, content-based restrictions are presumptively unconstitutional. To be valid, a content-based restriction must be necessary to serve a compelling state purpose and narrowly tailored to achieve that purpose. Content-neutral regulations, on the other hand, must be substantially related to a legitimate government purpose and leave open alternative means of communication. Vague and overbroad. Vague regulations on speech are regulations that are ambiguous and don't provide definite standards that allow for citizens to know how to comply with them sufficiently. As such, they are struck down as a violation of the First Amendment. Here, forbidding political signs is impermissibly vague because it does not sufficiently apprise citizens of what kind of signs constitute political signs. It is unclear whether that just pertains to elections, or if it also encompasses political ideology, thought processes, campaign financing, etc. This proposal is unconstitutionally vague and can be struck down on those grounds. First Amendment. Time/place/manner restriction. Proposal 2 regulates lighting for any and all sign placed on property. This is likely a permissible time/place/manner regulation. Time/place/manner regulations on speech are ones that are focused on the timing/placement of speech rather than the content/viewpoint of the speech. Time/place/manner restrictions are permissible so long as 1. They are content neutral, 2. Serve an important government interest, and 3. Leave open alternative channels of communication. Said differently, these restrictions are subject to a form intermediate scrutiny. First Amendment. Prior restraints. Prior restraints on speech are regulations that prevent or burden speech from happening before it has occurred. Generally speaking, prior restraints on speech are disfavored. Proposal 3 contains a licensing restraint that would require citizens to receive a license prior to installing lighting signs on their property. Prior restraints may be upheld so long as the standards for the restraints contain definite standards and don't allow for unfettered discretion in its application. Definite standards require that precise procedures be followed so that the people/public officials issuing the licenses do not have any room to exercise discretion in deciding whether to issue the license. Procedural due process. The federal Constitution provides, under the Fifth Amendment, that all persons are not to be intentionally deprived of life, liberty, and property without the due process of law. This provision is applicable to the states via the 14th Amendment. Procedural due process requires that individuals, prior to being deprived of any rights, are entitled to notice, a hearing in front of a neutral magistrate, and the right to be heard prior to being deprived of any of their constitutional rights. Due process. DUPA violates the Due Process Clause of the Fifth Amendment. The Due Process Clause of the Fifth Amendment provides that the federal government may not deprive U.S. citizens of life, liberty, or property without due process of law. Due process of law has been defined as the process that is due, which generally includes notice and a hearing before the termination of rights. The Supreme Court of the United States has identified two types of due process, substantive and procedural. Procedural due process provides that the government may not deprive persons of life, liberty, or property without due process of law. Citizens have property rights to public jobs, benefits, and licenses. Substantive due process provides that a person may not be deprived of a fundamental right without due process of law. Fundamental rights include the right to vote, the right to free speech, the right to privacy, and the right to interstate travel. The right to privacy includes the rights to contraception, abortion, marriage, procreation, education of children, and child rearing. Substantive due process violations are analyzed under strict scrutiny, so the government must prove that the law is necessary to achieve a compelling state interest and narrowly tailored to that interest. Taking. Under the Takings Clause of the Constitution, any individual who is deprived of their property by the government is entitled to reasonable compensation. Individuals are entitled to notice before their property is taken for public use. Under the Takings Clause, a person can be deprived of their property if the government either 1. Physically takes up a portion or all of their property, or 2. Regulates the property to such an extent that the property does not retain any economic value. Standing. The plaintiff has standing to bring this claim. In the United States and in Florida, an individual must have standing in order to bring a claim to challenge the constitutionality of a government action. The Constitution of the United States provides that U.S. courts are only permitted to hear cases and controversies In order for a claim to be a case or controversy, the plaintiff bringing the claim must have standing. Under Lujan versus Defenders of Wildlife, to have standing, a plaintiff must have suffered an actual or imminent injury. An actual injury is one that is concrete and not imagined. An imminent injury is one that is sure to happen, not just merely possible. The plaintiff's injury must be causally connected to the government's action. There must, therefore, be a causal chain linking the plaintiff's injury directly to the government's action. Finally, the plaintiff's injury must be redressable. A favorable ruling from the court must cure plaintiff's injury. Taxing and spending. DIPA is a proper exercise of Congress's power to tax and spend. Article 1 of the Constitution provides for the plenary power of the United States Congress. Among these powers is the power to tax and spend for the general welfare. The Congress of the United States is thus afforded plenary, or nearly absolute, power to levy taxes from the states in order to raise revenue for actions that are rationally related to the general welfare. Furthermore, Congress is permitted to spend money from the federal treasury in order to provide for the general welfare. Congress's spending power also extends to its power to allocate funds to the several states to serve the general welfare in the states. While Congress is prohibited from commandeering state resources or instrumentalities, see below, Congress, under its spending power, is permitted to condition spending on states' adherence to government initiatives. However, all of Congress's powers are subject to laws against discrimination, as will be explained below. Commerce Clause. DIPA is a proper exercise of Congress's commerce power. Like its taxing and spending power, Congress has a near-plenary power to regulate interstate commerce in the United States under the Commerce Clause of Article 1. This includes the power of Congress to set limitations on the use of commerce and the means and instrumentalities of interstate commerce that are rationally related to a legitimate government purpose. Means and instrumentalities of interstate commerce include roads, waterways, and vehicles. In addition to regulating interstate commerce itself, the Commerce Clause also permits Congress to regulate non-commercial activities that substantially impact interstate commerce in the aggregate. However, all of Congress's powers are subject to laws against discrimination, as will be explained below. Anti-commandeering. Furthermore, under federalism principles, the federal government may not commandeer the instrumentalities of the states. In other words, the federal government may not utilize their legislatures or agencies to enforce a federal law. This rule was developed by the Supreme Court in the case of Brady, where the federal government tried to force 24 states to use their police forces to conduct background checks on potential gun owners in order to enforce a federal gun regulation. Equal protection. The Equal Protection Clause prohibits discrimination on the basis of classifications. Where a law discriminates on the basis of a suspect classification, strict scrutiny is applied. The government must show that the law is necessary to achieve a compelling state interest. Where a law discriminates on the basis of a quasi-suspect classification, gender, and illegitimacy, intermediate scrutiny is applied. The government must show that the law is substantially related to an important government purpose. Where the law discriminates on the basis of a non-suspect classification, such as age or wealth, rational basis applies. The challenger must prove the law is not rationally related to a legitimate government purpose. Sovereign immunity. The state of FL may sue, through its Attorney General, for relief from unconstitutional legislation. To prevail, they must have standing and also assert a cognizable case against the government. The government is not immune from suits by the states in federal court. And the proper forum for an action between the state of FL and the United States would be the U.S. Supreme Court, who has original jurisdiction under the Constitution to hear a case between a state and the federal government. Any legislation that is constitutional at the federal level and conflicts with state legislation preempts the state legislation to the extent of any conflict. Federal acts which require a state to enact legislation may be unconstitutional as a commandeering of a state legislature to act. This is because of the protections of federalism in the U.S. Constitution, which prohibit the federal government from requiring states to enact legislation. However, the feds may condition certain funding on the passage of constitutional legislation. The U.S. Constitution requires standing, in addition to having a live case and controversy to allow a federal court to adjudicate the action. Bicameralism. Legislation of the United States works similarly to state legislation. There must be bicameralism, which means that the bill must originate in one house and pass in both houses by a simple majority. Additionally, there must be presentment, where the passed bill is presented to the president for signature. A president may choose to sign or veto a bill, and in the event of a veto, the Congress may repass the legislation over the president's veto by a 2/3 majority. Legislation that has not passed by one of these two methods is not current and enforceable legislation. Privileges and Immunities Clause. Privileges and Immunities Clause, because it seeks to discriminate or distinguish on the basis of in versus out-of-state residence on the issue of economic activity/livelihood. States may not discriminate on the basis of state residence absent a compelling and legitimate governmental interest, and if the mechanism employed is narrowly tailored and required to achieve that end. Contracts Clause. The federal Constitution prohibits a state from passing a law abrogating private contract rights. However, to fall afoul of the contracts clause, the contract needs to be in existence. A state law is not violative if it prevents the realization of future and not yet existent contracts. Contract law. Contract formation. Contracts for services are governed by the common law. For a contract to be valid, we need an offer, acceptance, and consideration. An offer is the outward manifestation of an intent to enter into a contract with certain and definite terms communicated to the offeree. Acceptance occurs when the offeree communicates an intent to enter into a contract. Consideration is a bargain for exchange. In Florida, consideration needs a benefit or legal detriment. Under the mirror image rule, acceptance must mirror the terms of the offer. Any change in the terms results in a counteroffer. A counteroffer is a rejection of the original offer and places the power of acceptance of the new terms in the hands of the initial offeree. Acceptance can also take place with performance. Statute of frauds. Statute of frauds requires that certain contracts be in writing, contain essential terms, and signed by a party to be signed. These contracts are contracts that cannot be completed within 1 year, contract for marriages, contracts for the sale of land, executorships, guarantees, and the sale of goods over $500. Liquidated damages. Natalia can argue that the early termination fee is not liquidate damages and is a penalty. Liquidated damages must reasonable and a reasonable forecast of the damages in the future. Anticipatory repudiation. A breach of contract is material when the breaching party fails to substantially perform according to the terms of the contract. A breach of contract can occur when one party repudiates the contract before performance is due. A repudiation must be clear and unequivocal, otherwise the non-repudiating party may only demand further assurances. The repudiating party may retract the repudiation unless 1. The non-repudiating party has relied on the repudiation to its detriment, 2. Has sued for breach of contract, or 3. Has 26 accepted the repudiation. In the case of repudiation, the non-repudiating party must suspend performance in order to avoid further loss to the repudiating party. Remedy, cost of cover, expectation damages. Expectation damages are meant to place the parties in a position as if the contract had been performed and to give the parties the benefit of the bargain. The non-breaching party has no duty to mitigate damages, i.e., failure to mitigate does not operate as a bar to recovery, but if there is a failure to mitigate damages, then this could reduce the amount of damages. If a seller breaches a contract, then the buyer is entitled to expectation damages. If the buyer must replace the goods, the damages are measured as the difference between the contract price and the cost for replacement. Consequential damages. Consequential damages are recoverable under the UCC. Consequential damages that include lost profits are available only if at the time of contacting the breaching party knew or had reason to know of the nature of potential losses, and such losses were a foreseeable event as the result of breach at the time of contracting. Duty to disclose. Under Florida law, a seller has a duty to disclose known material defects in a property that are not easily discoverable by a buyer. These latent defects must be those that are significant and that would make a buyer reconsider had he or she known of the defect. A defect that is observable or one when the buyer knew or should have known falls outside of this duty. Active concealment. In Florida, a seller is prohibited from actively concealing defects in a property. A seller cannot take steps to conceal the discovery of known material defects. The UCC applies to the transaction. The UCC Article 2 applies to all transactions in goods defined as movable things. Because a painting is a movable thing, the UCC applies to this transaction. Perfect tender. Under the UCC, the perfect tender rule generally applies unless it is an installment contract. When a seller tenders goods that fail to conform in any way to the underlying contract, the buyer typically has 3 options. She may 1. Accept the goods, 2. Reject the goods, or 3. Accept in part and reject in part. The buyer is entitled to sue for damages for any non-conforming goods, regardless of whether they are accepted. Parole evidence. The parole evidence rule bars use of contemporaneous oral or written agreements that contradict a writing evidencing an agreement or supplement a complete integration. However, oral agreements are admissible to clarify ambiguities or supplement partially integrated agreements. A patent ambiguity is one that appears on the face of the document. A latent ambiguity is not apparent on the face of the document. Furthermore, Scrivener's errors can be corrected through the equitable remedy of reformation if the writing does not reflect the mutually agreed on terms of the agreement. Specific performance. In regard to unique goods, the equitable remedy of specific performance is often appropriate. Specific performance is only available when the legal remedy would be insufficient. Governing law. Important to note at the outset that these are both contracts for personal services, therefore the common law of contracts will govern the disputes, whereas the UCC would govern a contract for the sale of goods. Breach. Under the common law, contract is breached when one party has an absolute duty to perform and the duty has not been discharged. Material breach, where a party is denied the substantial benefit of the bargain, discharges the other party's duties under the contract. Minor breach is where a party receives the substantial benefit of the bargain though imperfect performance, does not but allows for damages for defective performance. Additionally, the plaintiff will need to show that they are ready, will, and able to perform. Unilateral mistake. Unilateral mistake exists if 1. A factual mistake exists at the inception of the contract. 2. The mistake goes to a material aspect of the contract. 3. The party asserting mistake did not incur the risk of it. 4. The mistaken fact was an essential fact on which the mistaken party relied. And 5. The non-mistaken party knew of the other's mistake, but did nothing, or it would otherwise be unjust to enforce the contract. Modification. Under the common law, a modification to a contract must be supported by new consideration. Promissory estoppel. Alternatively, Lori could claim damages under a promissory estoppel theory. The elements of promissory estoppel are 1. The defendant made a representation. 2. The plaintiff reasonably, foreseeably, and detrimentally relied on the representation. And 3. The court will enforce the representation to the extent necessary to prevent injustice. Restitution. Alternatively, Addie could claim restitution for the payments she sent. Restitution claims involve showing 1. The plaintiff conferred a benefit. 2. The benefit was not gratuitous or officious. And 3. The defendant had an opportunity to reject it but did not. Third-party beneficiary. An intended beneficiary of a contract has the ability to sue the parties to the contract to ensure its enforcement or otherwise collect damages. And the intended beneficiary's claim is subject to the same defenses as might be asserted against the parties. Condition. For a party to become liable on a promise, all express conditions precedent to that promise must be fulfilled. Moreover, the default rule is that parties must comply 100% with express conditions. Intended beneficiary. Moreover, FB was the intended beneficiary. Two parties can agree to benefit a third party, and if that third party is an intended beneficiary, then that third party can enforce the contract. Reasonably, foreseeably, and detrimentally relied on the representation. And 3. The court will enforce the representation to the extent necessary to prevent injustice. Mistake. When there is mutual ambiguity or mutual mistake that goes to an essential element of the agreement, and both parties were unaware of the ambiguity or mistake, the agreement may be rescinded and each party shall be entitled to claim in restitution anything they gave of value. If one of the parties is aware of the ambiguity or mistake and the other party is not, the contract may be enforced in favor of the party that was not aware of the ambiguity or mistake. Mixed contract. The agreement is a mixed agreement of intellectual property, patents, and licensing of the kits, and a contract for the sale of goods. The UCC covers the sale of goods which are tangible movable property. DNA kits are movable goods and therefore subject to the UCC. SF applies to contracts for sale of goods that are more than $500 in value. Battle of the forms. Under the UCC, which could apply to the text kit but not the patent, amended terms are only accepted if they do not materially change the offer, or the offer was not expressly conditional to acceptance of its terms, or the offeror does not object within 10 days. Accord and satisfaction. Accord and satisfaction. When there is a dispute as to a debt, a party that offers a lower amount in satisfaction of the debt and rights paid in full fully performs and is discharged. Ads. Generally, advertisements are considered an invitation to negotiate and not an actual offer. The only exception is where there is specific language which indicates how to complete the sale, such as a store advertisement stating, first come, first served. Mailbox. Mailbox rule applies, which states that acceptance occurs upon placing acceptance in the mail and not upon receipt of the acceptance. UCC acceptance. Under the UCC, acceptance can be by shipment of non-conforming goods. If the seller of goods would like his shipment not to be an acceptance, it must be accompanied by a notice of accommodation. If it were accompanied with a notice of accommodation, then we would have a counter-offer instead of acceptance and breach. Merchant confirmatory exception. Under the UCC there is the merchant's confirmatory memo exception. Under this exception, if the merchant receives a memo from the other party confirming the terms of the agreement and does not object within a reasonable time, this writing may be used against him, her/it to satisfy the statute of frauds. Modification of contract. Under the UCC, in contrast to the common law, there does not need to be additional consideration to support a contract modification. Rather, the UCC simply requires that the contract modification be made in good faith. Express warranty. There are 3 major kinds of warranties relating to the sale of goods. An express warranty is created by a particular express representation, statement, model, design, or sample, indicating that the good to be sold is of a particular status or quality, but not a general recommendation or commendation of any good. Warranty is the implied warranty of merchantability. This warranty applies only to goods sold by merchants. Here, seller is the owner of a piano store and so is a merchant. The implied warranty of merchantability is a warranty that the goods sold are fit for their ordinary purpose. Implied warranty of fitness of a particular purpose. Faith. This warranty applies to sales of goods by both merchants and non-merchants when the seller knows that the goods are purchased for a particular purpose, and the buyer relies on seller's skill or judgment in order to choose a good. Disclaimer of warranty. Warranties may be disclaimed, but generally such disclaimers must be specific and not hidden. When a disclaimer of a warranty contradicts an express warranty, moreover, the contradiction is resolved in favor of upholding the warranty. A generalized disclaimer, such as is often insufficient. This particularly applies to consumer goods, goods for personal or household use, such as a baby grand piano. Expectation damages. Expectation damages, which aim to give the non-breaching or innocent party the benefit of his bargain. As an alternative, in appropriate cases, the non-breaching party may be able to recover restitutionary damages, reliance damages, or specific performance. Punitive damages. Generally, punitive damages are not recoverable in contract unless there is an independent tort committed. Note that under the doctrine of election of remedies, a party cannot get a double recovery. He cannot choose, for example, both restitutionary and expectancy damages. Impracticability. He would have to show that an unforeseen event, the non-occurrence of which was a presumption of the parties, materially altered his performance to such an extent that performance is excused. UCC gap fillers. However, under the UCC, whenever there is a term left open to be determined, the UCC has gap fillers which can allow the court to imply a term into the contract. Impossibility/impracticability. Enforcement of an agreement is impossible when there is no way a party can perform under a contract. It is impractical when there is an unforeseen occurrence that renders performing very difficult. Counteroffer. A counteroffer is considered a rejection of the original offer and the making of a new offer. By making a counteroffer, the seller effectively rejected buyer's January 30th offer, which terminates the offer, and made a new offer with different terms. The mirror image rule dictates that an acceptance must match exactly the terms of the offer in order to be an effective acceptance. Duress. Duress occurs where a party's free will has been overcome due to the circumstances surrounding the transaction and, as such, did not voluntarily enter into the contract. These circumstances can be found where one party has made an improper threat to another party that has caused that party to involuntarily enter into the contract. Reliance damages. Reliance damages seek to return the non-breaching party to the position they were in prior to the contract being formed, thereby returning funds and other items expended pursuant to the contract. Incidental damages seek to remedy damages incurred incident to the breach, such as inspection fees, storage fees, having to remarket property, etc. Restitution. In addition, parties can seek to recover any unjust enrichment conferred upon the other party, even if the court finds that there was no validly enforceable contract under a theory of restitution. Criminal law. Burglary. Burglary is a specific intent offense. At common law, burglary was defined as the 1, breaking, and 2, entering, 3, of a dwelling, 4, at nighttime, 5, with intent to commit a felony therein. Today, modern courts have abolished the requirement that the crime occur at nighttime or that the structure is a dwelling. Now, burglary typically requires either the unlawful breaking and entering of a residential or commercial structure that is not a public place during business hours with the intent to commit a felony therein, or unlawfully remaining in a building after it closes with intent to commit a felony therein. Breaking occurs when an individual uses any force to open any access to the building, window, door. Breaking does not occur when a door is wide open, but will occur if any force is used to open the door. Further, burglary still occurs even if the defendant doesn't actually commit the felony. He need only have the intent to commit the felony therein. Arson. Arson is a general intent malice offense. At common law, arson was the reckless or intentional setting aflame of the dwelling of another. Today, arson is committed when an individual recklessly or intentionally sets fire to any building, not just homes. Though scorching of a building wouldn't constitute arson, charring will suffice. Attempted murder. Attempt is an inchoate offense. To be guilty of attempt, one must commit a substantial step towards committing the crime. At common law, murder is the unlawful killing of another with malice aforethought. Murder may be committed if the defendant, 1, intentionally kills or causes great bodily harm to another, 2, a killing during the course of an enumerated felony, battery, arson, assault, robbery, rape, kidnapping, drug trafficking, 3, murder in connection with drug trafficking, and 4, depraved heart murder, which is a killing involving reckless indifference to human life. Murder also requires actual and proximate causation. Actual causation means that but for the defendant's act, the crime wouldn't have occurred when it did. Proximate causation requires the harm to be foreseeable. Vehicular homicide. Under the relevant Florida statute, to commit vehicular homicide one must, 1, operate a motor vehicle in a reckless manner likely to cause the death of or great bodily harm to another, and 2, such action must result in the killing of a human being. Further, one need not know that the accident resulted in injury or death. Conspiracy. Florida retains the traditional rules for conspiracy where there must be a meeting between two people to engage in an illegal act. In other words, both of the participants of a conspiracy must actually have the intent to engage in the prohibited conduct. Under Florida law, no overt act is required to complete the crime of conspiracy. For those who enter into a conspiracy, each party can be convicted of both the underlying conspiracy and any crimes that occurred during the undertaking of the conspiracy. Accomplice. Under Florida law, an accomplice can be held liable to the same extent as the principal, David, if the accomplice offers encouragement to the principal who is committing the crime. Arson. Arson is a general intent malice offense. At common law, arson was the reckless or intentional setting aflame of the dwelling of another. Today, arson is committed when an individual recklessly or intentionally sets fire to any building, not just homes. Though scorching of a building wouldn't constitute arson, charring will suffice. Attempted murder. Attempt is an Inca hate offense. To be guilty of attempt, one must commit a substantial step towards committing the crime. At common law, murder is the unlawful killing of another with malice aforethought. Murder may be committed if the defendant, 1. intentionally kills or causes great bodily harm to another, 2. a killing during the course of an enumerated felony, battery, arson, assault, robbery, rape, kidnapping, drug trafficking, 3. murder in connection with drug trafficking, and 4. depraved heart murder, which is a killing involving reckless indifference to human life. Murder also requires actual and proximate causation. Actual causation means that but for the defendant's act, the crime wouldn't have occurred when it did. Proximate causation requires the harm to be foreseeable. Statutory rape. A defendant commits statutory rape by engaging in sexual intercourse or acts with a child under the age of majority. The age of majority is 18. If the elements of the crime do not have a scienter or mens rea requirement, it would be considered a strict liability crime. Robbery. Robbery requires a theft be committed pursuant to force or the threat of force. Force that is used after the theft of the property itself is sufficient. The two elements must be temporal. There are also aggravating circumstances that may make the robbery an aggravated robbery or armed robbery, which is a more serious offense than robbery itself. In Florida, this includes, for example, the use of a weapon to complete the robbery. Battery. A battery occurs by making an unconsented to of an individual's person that would be offensive to a reasonable person. An individual's person includes their clothing or anything they're wearing. Larceny. Larceny is the intentional taking and carrying away the personal property of another with the intent to deprive them thereof. Felony murder. Felony murder is when during the commission of an enumerated felony, burglary, arson, robbery, etc. a murder is committed in the furtherance. Solicitation. Solicitation is an inchoate crime where the defendant enlists or asks another person to commit a crime. The request alone is enough to make a prima facie case for solicitation. Accessory before the fact. An accessory before the fact, which is when any person aids another in the future commission of a crime. The aid here was the location of the wire and instructions on when to go steal it. This is also an inchoate crime which merges into the completed offense and would merge with the conspiracy and theft charges. Common law murder. Under the common law, murder is the taking of a human's life with a depraved heart. Florida has adopted the common law definition and further calls murder that is not premeditated or deliberate as second-degree murder. Depraved heart is evidenced by 1. Intent to kill, 2. Intent to commit serious bodily injury, 3. Super reckless disregard of the dangers to human life, or 4. As a result of a non-prenumerated felony. Involuntary manslaughter. Evidenced by 1. A killing committed during a misdemeanor or a crime not classified as a felony, or 2. Reckless indifference to life that lead to death of a human. Possession of a controlled substance. Florida makes it a crime to knowingly transport, sell, or possess a controlled substance. Insanity, not in theory. Must be proved by clear and convincing evidence and raised by the defendant with the burden of proof on the defendant. Insanity means that the defendant did not have the legal capacity of mind at the time the crime was committed to be charged. The not in theory follows that because of a disease of the mind, the defendant did not know her actions were wrong, did not know right from wrong, or did not understand the unlawfulness of her actions. Real property law. Transfer of deed. A deed transfer need not satisfy the statute of frauds, but the grantor must have the present intent to transfer. It must be in writing, signed by the grantor, name the grantee, contain a reasonable description of the property, and be witnessed by 2 attesting witnesses. Recording a deed is a presumption of the intent to transfer. Tenancy by the entirety. Tenancy by the entirety requires unity in time, title, interest, and possession. This means that the tenants must take an interest in the property at the same time. The land must be granted to the tenants in the same instrument. Like the deed, their interests have to be equal, such that, for example, one party does not have a life estate when the other party has a fee simple, and they must have the same right to possession, so that both tenants have a 50-50 interest in the property. In Florida, married couples are presumed to be tenants by the entirety unless otherwise specified. Mortgage. A mortgage is a property interest that attaches to the land until terminated. Florida is a notice jurisdiction state. A property interest, like a mortgage, is only valid against subsequent purchasers for value if they have notice or the prior interest is recorded. Foreclosure. A mortgagee may foreclose on property when the underlying obligation to which it relates is in default, typically due to a failure to make payments. To foreclose on property, Florida requires the plaintiff show standing. He must show that he is the owner of the note and obtained ownership prior to the foreclosure action. Ownership may be proven through an unbroken chain of self-authenticating assignments. He must also name the parties to the foreclosure action. Priority. Foreclosure of a senior interest at a judicial sale eliminates all junior interests on the property so long as notice is given to the junior interest. Whether an interest is junior or senior is determined by the first in time, first in right rule. Deficiency. Florida allows for deficiency judgments. If the foreclosure of the mortgage property is not enough to cover the amount of the debt that it relates to, the mortgagee may recover the deficiency from the mortgager. Purchase money mortgage. A purchase money mortgage exists when the mortgagee gave the loan that allowed the mortgager to purchase the property. A purchase money mortgage has a superior interest over other creditor interests. Express easement. An express easement is created when parties agree to allow a dominant estate a specific use on a servient estate. A person using an express easement beyond the stated use is liable for surcharge for the value of the overuse. Eviction. The right to evict a tenant belongs to the estate owner. Unless otherwise agreed, only material breaches of a lease will permit eviction. Minor breaches only permit damages as a breach of contract. Absent a breach or other lease terms, a tenant cannot be evicted. Termination of easement. An express easement is generally irrevocable absent all parties' agreement. However, overusing the easement may give rise to a surcharge action. See above for discussion. Mortgage transfer. Generally, when a mortgagor transfers his interest to a new buyer before the mortgage is paid off, the buyer takes the property subject to the loan. While the lender may still foreclose on the property, the buyers will not be personally liable and do not need to cover any deficiencies. However, sometimes the buyers will agree with the seller to assume liability for the mortgage. Tenancy severance. A lien holder only has an interest in that tenant's estate. Moreover, when a piece of property is granted to a married couple, and the deed says, and both spouses must agree before transferring interest in the property. Valid deed. In order for a deed to be valid under Florida law, it must be attested by 2 witnesses, contain an accurate description of the land, and properly delivered. In order for a deed to be properly delivered, physical delivery is not required. Delivery to a third party on behalf of the recipient is enough to constitute delivery under Florida law. Statute of Frauds. The sale and lease of land falls under the Statute of Frauds, SF, and thus must be reduced to a signed writing in order to be enforceable. The signed writing must include the names and signatures of the parties to be charged, an adequate description of the land, and a sale price if it is determinable. Periodic tenancy. Actual waste. That not permit. As a life estate holder with interests that will follow your interest, you have a duty to not commit waste on the property. There are 3 different types of waste. 1. Actual. 2. Permissive. 3. Ameliorative. Actual waste is exploiting the natural resources that are already on the land. The owner of the property is not permitted to overuse the recourses on the land so as to drain the land of its natural resources unless the land is only good for that reason, the landowner was given permission to do so, or it was previously used for that reason. However, if it was previously used for that reason, the current landowner is restricted to only using what is already there under the open mines doctrine. This means that the landowner cannot open new mines for excavation, but must work with what is already pre-existing. Permissive waste. Permissive waste refers to keeping the land in good condition. The landowner has a duty to maintain the land in a good condition. This just means any ordinary wear and tear on the premises and not allow the land to go into disrepair. This also means paying taxes on the land. Ameliorative waste. Finally, ameliorative waste refers to waste that improves the value of the land. The landowner must not make substantial changes to the land that improves the value of the land. Real estate contract. Alternatively, in a Real Estate 7 contract, the Statute of Frauds may be satisfied by showing 2 of the following 3 facts. 1. Payment of purchase price. 2. Physical possession of the land. And 3. Improvements to the land. Equitable conversion. When parties enter into a contract to buy property, the doctrine of equitable conversion provides that the buyer is the owner of the property and has the risk of loss as of the signing the contract. Title severance. Florida is a lien state, meaning that a mortgage acts as a lien on the property. The mortgagee, in this case seller, does not have title to the property, just a lien. Easement by necessity. An easement by necessity arises where one property is divided, and that creates a situation where there is no other way to access a public road. An easement by necessity can terminate if that necessity is no longer there, such as a new road being built. Easement by adverse possession. In order for this easement to arise, there must have been access that was hostile or adverse, continuous, open and obvious, and for the statutory period. In Florida, that period is 20 years. Adverse possession. In order to prevail for a claim of adverse possession, the adverse claimant must prove that her use was open and notorious, hostile and under a claim of right, continuous for the statutory period, and exclusive under the common law. The period of time for common law is 20 years. An adverse claimant may also claim adverse possession pursuant to statute under color of title or without color of title. To prove under color of title, the adverse claimant must record the deed with the county clerk which purports to vest title in the adverse claimant. To prevail on a claim without color of title, the adverse claimant must make a return with the tax assessor and pay the taxes on the property claimed. Both under color of title and without color of title require the claimant to be in possession for 7 years. Easement by prescription. Owner must prove that her use of the road was open and notorious and continuous for 20 years in order to establish an easement by prescription. She must also prove it was hostile and adverse to the northern owner's interest. Non-disclosure. Under FL law, a seller of new or used residential property has a duty to disclose known material latent defects of the property that are known to the seller and not known or reasonably attainable by buyer. Material defects are defined as defects that, if known, would cause a reasonable buyer to have second thoughts about purchasing the property. However, buyers are assumed to take precautions when purchasing property, such as ordinary inspections. Parties can have notice of defects in 3 ways: constructive, where party discovers defects; inquiry, where some act puts them on notice that they should investigate further; or actual, where they were told. Under FL law, sellers of commercial property are not held to the same standard as residents and are not required to disclose defects. Parties are not living in them, and therefore buyers have a greater duty to inspect. Damages, real estate. Expectational damages, designed to put the person in a position if the K had been performed, usually market price versus contract price. Reliance damages, damages that are designed to give buyer back money they spend in reliance of contract. Or restitution damages, which are used by the court to prevent unjust enrichment. Recording deed. Florida is a pure notice jurisdiction which protects a bona fide purchaser, BFP. A purchaser is bona fide if they subsequently pay value for the land and have no notice of anyone's prior interest in the land. Therefore, the time and order of the recording of the deed is not critical to the validity of the deed. However, the recording of a deed is to give notice to the whole world of your interest in the property, record notice. Therefore, every purchaser should record their deed in order to prevent his interest in the property from being unenforceable against a subsequent BFP. A deed becomes enforceable once it is executed and delivered to the grantee. Homestead. The Florida Constitution provides homestead protection for qualified property against the forced sale by creditors. A property qualifies as a homestead if it is owned by a person, they are domiciled there, and it meets the acreage requirements. If the property is located within a municipality, it extends to 1/2 acre contiguous land and its improvements. If the property is located outside the municipality, it protects 160 acres of contiguous land and its improvements. If the property has homestead protection, the Constitution restrains the devise of the property if there is a surviving spouse or minor children. If there is a surviving spouse and no minor children, then the decedent may convey to the surviving spouse outright. If there is a surviving spouse and surviving minor children, then the decedent may not devise the property. If the decedent is not survived by a surviving spouse or minor children, he may dispose of the property how he pleases. If there is an improper devise, the property passes as it would in intestacy. Therefore, if there is a surviving spouse and 1 or more lineal descendants, then the surviving spouse will get a life estate and the lineal descendants will receive a vested remainder, per stirpes. If property is titled to a husband and wife, Florida presumes a tenancy by the entirety. If there is a tenancy by the entirety, there is no homestead protection. If husband and wife are married and they have either a homestead or tenancy by the entirety, both spouses have to join in the conveyance or mortgage of the property. General warranty deed. A general warranty deed contains 6 covenants of title. 1. Covenant of season, which says that the owner actually owns the property he is seeking to convey. 2. Covenant of right to convey, which means that the owner has the right to convey the property he claims to own. 3. Covenant against encumbrances, which means that the seller guarantees that there are no encumbrances on the property that were not previously disclosed. 4. Covenant of quiet enjoyment, which means that the seller will not be ousted from the property by someone claiming paramount title. 5. Covenant of warranty, which means that the seller will defend from any suits brought by someone claiming paramount title. And 6. Covenant of further assurances, which means if the seller did not convey valid title, he will do whatever is necessary to do so. Special warranty deed. However, under a special warranty deed, seller only covenants that he or she did not convey the land to someone else and that he or she did not encumber the land during ownership. The facts state that seller delivered a special warranty deed. Recording statute. Additionally, Florida is a pure notice jurisdiction. Notice can be by actual notice where the buyer knows of any claims to title, constructive notice where the buyer is on notice if the instrument is recorded, or inquiry notice where a seller has a duty to inquire into the land. Non-disclosure. In Florida, the seller of residential real estate has an affirmative duty to disclose all facts materially affecting the value of land that are known or should be known to the seller, but are not readily discoverable to buyer upon a reasonable inspection. Something materially affects the value of land if a reasonable person would think twice about entering into the contract if the fact were known. Intentional misrepresentation. Intentional misrepresentation requires 1. A false statement of material fact. 2. Scienter or knowledge of the falsity of the fact. 3. Intent to induce the other party to rely on the misrepresentation. 4. Justifiable reliance by the buyer. 5. Causation. And 6. Damages. Fraudulent misrepresentation. Fraud when there is 1. Active concealment of a latent defect in the property. 2. An affirmative lie. Or 3. Silence when there is a duty to speak. Scienter, knowledge of the falsity, must be proved and there must be justifiable reliance, causation, and damages. Covenant of season, which warrants that the title is marketable and good and that there is nothing of record that affects the title. Covenant of warranty and defend, which promises that owner will show up to defend his ownership in the property should any lawsuits arise. Covenant to convey, which promises that owner had the right to convey the property. Covenant of quiet enjoyment, which promises that no one has a lawsuit against the property and buyer can own it in peace without worrying that he will be thrown off it. Covenant of future assurances. Owner promises that he will execute all paperwork or do anything in the future he needs to do regarding the property. Covenant against encumbrances, which promises that owner didn't have encumbrances or liens on the land other than what owner has told buyer about. Tort law. Negligence. In order to maintain a claim of negligence, the plaintiff must prove duty, breach, causation, and damages. Duty. Rule. People in Florida have a duty to all foreseeable plaintiffs. The duty is to act as a reasonable, prudent person, and this is an objective standard. Breach. When a person deviates from the applicable standard of care, they are in breach. Causation. In Florida, there is causation if there is both cause in fact and proximate cause. But for causation is actual causation, but for the defendant's negligence, plaintiff would not have been harmed. However, when there are 2 or more actors responsible for indivisible injury, the actual cause test is met as long as the defendant's actions were a substantial factor in causing harm to the plaintiff. Proximate cause focuses on foreseeability. The question is whether the harm that resulted was a foreseeable consequence of the act that made defendant's actions negligent in the first place. Damages. In Florida, the measure of damages for negligence is compensatory damages. Compensatory damages are the damages necessary to put plaintiff back into the position they were in before the negligence occurred in order to make them whole. There must be physical harm or harm to property. Pure economic loss is insufficient for negligence. However, should the plaintiff prove the requisite injury, then they are entitled to non-economic damages like pain and suffering, but also economic damages like medical expenses and lost wages. Negligence defenses. In Florida, there are certain defenses to negligence. First, we should note that Florida has abolished joint and several liability, and, to the extent a defendant wishes to raise the comparative negligence of a third party, she must identify that party and their action in her pleadings. Florida is a pure comparative negligence state. This means that a plaintiff can recover even if she was negligent and her negligence caused part of her damages, even up to 99% of her damages in that case, she would recover 1% of her damages from the defendant. Vicarious liability. An employer is liable to an employee who causes harm to another when they are acting within the course and scope of their employment. Joint and several liability. At common law, a defendant could be held jointly and severally liable with co-defeasors. This meant that the plaintiff could go after any one defendant for all of the harm and the defendant could then sue the co-defendant for their portion of the damages. However, Florida has abolished joint and several liability. As such, each defendant is only liable for their own proportional share of the harm. Contributory/comparative negligence. Florida is a pure comparative fault jurisdiction. This means that the plaintiff can still recover even if they were more at fault than the defendants. The plaintiff's share of fault would reduce their overall recovery. However, if the plaintiff were legally drunk and more than 50% at fault, then they would be barred from recovering. Intervening and superseding causes. After the defendant's negligence, the defendant will be liable for all harm that is foreseeable. Foreseeable harm is called an intervening cause. Superseding causes, however, are not foreseeable and cut off the defendant's liability. Superseding causes are things like acts of God, intentional torts by third parties, and crimes by third parties. Negligence of others is foreseeable. Negligent infliction of emotional distress. If a defendant places a plaintiff in the zone of danger, then a plaintiff may recover for severe emotional distress if there is a physical impact, or there is a physical manifestation of symptoms. If the plaintiff is a bystander, then there is still a way to recover for NID. That is, the bystander plaintiff must have been closely related to the victim, the plaintiff must have been in the presence of the victim, and the plaintiff must have perceived the injury. Intentional infliction of emotional distress. To recover for intentional infliction of emotional distress, IED, the plaintiff needs to prove that the defendant acted intentionally or recklessly with extreme and outrageous conduct to cause plaintiff severe emotional distress, and that plaintiff did suffer severe emotional distress. Extreme and outrageous conduct is conduct outside the bounds of civilized society. In addition, plaintiff does not need to manifest physical symptoms. Battery. To bring a battery claim, the plaintiff needs to show that the defendant intentionally caused a harmful or offensive contact with plaintiff or plaintiff's person, and that such contact occurred. Defamatory statement. Fault. A public figure must prove that the defendant made the defamatory statement with actual malice, that is, knowledge that the statement was false or reckless disregard for the truth. If plaintiff is a private figure, then all they must prove is negligence. A public figure is generally a celebrity or someone who holds themselves out to the public or involves themselves in topics of public concern. Libel versus slander. Libel is printed defamation, slander is spoken. Slander requires actual proof of damages unless slander per se, while libel does not require such proof. However, libel by a media defendant does require proof of damages, and damages are never presumed. Furthermore, against a media defendant, the plaintiff can send a request for a retraction, and, if the media defendant complies, then plaintiff is limited only to actual damages. Qualified privilege. A qualified privilege exists when a statement, otherwise defamatory, is made by an individual in good faith, with an interest in making the statement, and limited in scope to the interest he has. Punitive damages. Punitive damages must be pleaded specifically and are permitted when the trier of fact finds that the defendant acted intentionally or with gross negligence. Punitive damages are capped at the greater of $500,000 or 2x special damages. In limited circumstances when the plaintiff can show the defendant knew of the risk and decided to proceed for purely pecuniary reasons, the plaintiff may recover $2 million or 4x special damages. Invasion of privacy. Vera will likely bring a claim against the Orlando Star for invasion of privacy. Included in the tort of invasion of privacy is intrusion into plaintiff's private affairs or seclusion. Intrusion into plaintiff's private affairs requires an actual intrusion into something that a reasonable person would keep private. Invitee. A duty can arise from a number of different relationships. Duties can be contracted for, they can be statutory, or can arise from a specific type of relationship, such as parent/child or teacher/student. As mentioned above, the duty owed to Val and Fred by Toolmart is that owed to a business invitee. A duty to a business invitee only goes to the extent of the invitation. If Fred were to wander into an employees-only area and become injured, he would likely not be able to bring a claim against Toolmart as he would have exceeded the scope of the invitation. Strict products liability. For liability to stand, she would need to show that manufacturer is in the business of making and selling such products, that the product is unreasonably dangerous to an average consumer, causation, and damages. Design defect. Under design defect is failure to warn or instruct. Amy has a strong case of showing duty/breach under strict liability. Punitive damages. In Florida, punitive damages must be pleaded with specificity to the trier of fact, who must find by clear and convincing evidence that the individual is guilty of intentional misconduct or gross negligence. For an employer or other individual to be liable for punitive damages due to a contractual or agency relationship, the principal, or A in our situation, must have either 1, condoned or ratified the conduct, 2, participated in conduct that lead to the injuries, or 3, been grossly negligent. Vicarious liability. Vicarious liability is holding an individual accountable/liable for the acts of its agent or employee. Assault. Assault is an intentional tort, which requires a showing that the defendant intentionally placed the plaintiff in a reasonable apprehension of an immediate offensive contact or touching. Invasion of privacy/disclosure of public facts. FL does not recognize a separate tort of false light, but does recognize invasion of privacy in disclosing private facts. This tort requires publication of private facts. False imprisonment. False imprisonment is an intentional tort wherein a defendant intentionally confines an individual by force or threats of force, against their will, and wrongfully. Shopkeeper's privilege. However, in Florida, shopkeepers have a privilege that allows them to detain certain individuals in certain circumstances. In order for the shopkeeper's privilege to apply, the shopkeeper must have a reasonable suspicion that a tort or crime has been committed and then may reasonably restrain the suspect, no force, for a reasonable time to investigate the suspected wrongdoing. Trespass to land. Trespass to land is the voluntary intentional physical invasion into the real estate of another. Causation must also be proved. Fraud/misrepresentation. Intentional misrepresentation occurs when there is a misrepresentation, there is scienter, the party relies on the misrepresentation to buy the product and is harmed by it. Negligence per se. Malpractice. Where one sues a doctor for malpractice in Florida, there must first be a pre-suit investigation conducted prior to filing the suit. Before notice to the parties, the plaintiff must have a doctor investigate the cause of action to determine that it is legitimate. Then the plaintiff must provide notice to all parties involved, 90 days prior to filing suit. The notice must include the affidavit of the investigator. During the 90 days, the statute of limitations is told and the defendant investigates the action and determines whether he will offer settlement, deny, or admit liability and litigate the damages. If the parties determine to litigate the damages, then they may elect to go to arbitration. If arbitration is unsuccessful, then the plaintiff has 60 days or the remainder of the statute of limitations to file suit. In arbitration as well as in court, there is a cap on the damages recoverable in malpractice cases. If the plaintiff decides to go to court on the issue of damages and forego arbitration, then the cap is $350,000 as opposed to $250,000 in arbitration. The cap in court for a disabled person in an emergency setting ranges from $1.5 million to $500,000 depending on the damages. A practitioner must show that he behaved as a practitioner in similar standing according to the similar community standard and acted accordingly as a prudent practitioner would. Florida also takes into account specialty, joint and several liability. The doctrine of joint and several liability was recently abolished in Florida. Each defendant in this case could be joined and the amount of damages for each allocated to that party. If there were joint and several liability, then the court would first deduct any damages attributable to the comparative negligence of the plaintiff. Florida uses a pure comparative negligence, which allows the plaintiff to recover regardless of his amount of fault. With joint and several liability, all defendants would be liable for the entire amount, although the plaintiff would be entitled to only one recovery. The paying defendant would then seek contribution from the other tortfeasors. Currently in Florida, without joint and several liability, the damages to each defendant would be apportioned, and the plaintiff would be able to recover only that 16 amount from each defendant. If a negligent party is dropped from the case, that party may still be liable as a faubre defendant, and the damages offset by the amount of that tortfeasor's liability. Landowner duty, business. As owner of the pub, owed a duty to his patrons to keep the public areas of the premises reasonably safe and to warn his patrons of any dangers. Because his patrons are public invitees, owner must make reasonable investigations and maintain his premises in good repair. Rescuer. Many states have Good Samaritan laws that protect rescuers from negligent actions in the course of a rescue, holding rescuers liable only for gross negligence, intentional misconduct, or willful and wanton behavior. The policy is to encourage people to take affirmative acts when they are generally under no duty to do so. Florida's Good Samaritan statute, however, does hold rescuers liable for their negligence. Florida's Good Samaritan statute extends protection to emergency room, ER, doctors as well. Florida protects ER docs so long as their conduct is not reckless. Attractive nuisance. Florida's attractive nuisance doctrine applies to children who are lured onto another's land by an artificial element. Duty owed to trespassers. The duty owed by a landowner to a person on his land is dependent upon the status of the person on the land. Greater duties are owed to invitees than to licensees than to trespassers. Trespassers are further classified as known or unknown. The general duty owed to unknown trespassers is to not inflict any affirmative harm, e.g. no spring guns. Since they are unknown, by definition, there is no duty to warn them of hazards on the property. In contrast, some trespassers are known, and they are owed the additional duty of warning of any hidden trap on the property. Misappropriation. There is probably not a cause of action for commercial appropriation, as this tort usually requires that the plaintiff show that the defendant is using her name or likeliness for a commercial advantage. This is usually proven by way of the use of a celebrity's likeliness in an advertisement or commercial promotion. Criminal procedure law. Legality of the search. Both the Fourth Amendment to the U.S. Constitution and Florida's Constitution, which mirrors the Fourth Amendment, prohibit unreasonable searches and seizures of individuals' persons, houses, papers, and effects without a warrant issued with probable cause, absent an applicable exception. Warrantless searches of a home are presumptively unlawful. Fourth Amendment protection is especially strong in constitutionally protected areas like the home. Law enforcement is prohibited from unreasonable searches in the curtilage of the home or inside it. Exceptions to the warrant requirement to search a home include 1. Exigent circumstances justifying the search. 2. Rendering emergency aid to an individual inside the home. 3. Prohibiting an individual inside from destroying transitory evidence. 4. Searches incident to lawful arrest. And 5. Consent searches. Consent may be given to search a home by the person who owns the home or lives in the home and is old enough to consent, and anyone who has apparent authority, meaning the officer reasonably believes that the individual can grant them authority to search the house. If one resident rejects consent, an officer may not search the home at that time. However, if officers arrest the individual for other reasons and return to the house and gain consent from another occupant, they may search the home with the individual's consent. Search incident to arrest. The general rule is that police do not need an arrest warrant to arrest someone in a public place so long as there is probable cause that they have committed a crime. Exigent circumstances. The officer would argue that he had an exception to the warrant requirement, the hot pursuit exception. Under this exception, officers do not need a warrant when they are in hot pursuit of a felon who enters into a building. Plain view. If an officer is legally inside someone's home, they do not need a warrant to seize any illegal items/evidence of a crime that is in plain view under the plain view exception. Inevitable discovery. However, one of the exceptions to the fruit of the poisonous tree exception is inevitable discovery, i.e., the evidence would inevitably have been seized regardless of the illegal conduct. Technology search. Although officers generally may search a person as a search incident to a lawful arrest, courts have held that due to modern technology and the amount of information we have on our cell phones, especially smartphones, people have a reasonable expectation of privacy in their phones, and police generally need a warrant to search a phone. Miranda confession. Under the Fifth Amendment to the U.S. Constitution, any person who is in custody and undergoing interrogation must first be given Miranda rights. Otherwise, anything they say can be excluded. A proper Miranda warning gives a suspect notice that they have a right to remain silent. Anything they do can and will be used against them in court, that they have a right to an attorney, and if they cannot afford an attorney, one will be provided for them. Here, the officer never gave David a Miranda right before David made the statement. Thus, if David can show he was, 1, in custody and, 2, the statement was a result of custodial interrogation, he can have his statement suppressed. Custody. Interrogation. Whether something is an interrogation is whether the police make a statement or action that reasonably would make the suspect make incriminating statements. Double jeopardy. Criminal defendants have the due process right under the Fifth Amendment of the United States Constitution that they may not be placed in jeopardy twice for the same offense. This rule applies to the states through the 14th Amendment. Jeopardy attaches in a jury trial when the jury panel has been sworn in. Jeopardy attaches in a bench trial when the judge commences the proceedings. It is not clear whether this is a jury trial or a bench trial, but because the trial has clearly proceeded, jeopardy has clearly attached. Once jeopardy attaches, a defendant may not be trial again for a charge if the fact finder makes a finding that the defendant is not guilty of that specific charge. Additionally, a defendant may not face trial again on that charge if on appeal a court of appeals finds that there was insufficient evidence to support the charge. However, if the trial is either abandoned for a mistrial, the defendant can be placed in jeopardy again for the charge. Additionally, if the case is appealed and a court of appeals overturns the case for any reason other than the sufficiency of the evidence, the defendant may be trial again. Warrant requirement. In general, a warrant is required before a search is conducted of someone's home. This warrant must be backed up by probable cause and describe with sufficient particularly the items and areas to be searched for and/or seized. Once the particular item is found, the search must cease. The police are allowed to perform a protective sweep if they have reason to believe that someone else might be in the home. There are several exceptions to the warrant requirement, which will be discussed below. Consent. Consent is another exception to the warrant requirement. If a person consents to the entry or to the search, then there is no warrant that is required. The fact pattern says that the house belongs to both Mary and David. Curtilage. The court has ruled that you have a reasonable expectation of privacy to your home, as well as the curtilage of your home, which is the immediate area surrounding your home. In other words, a police officer is not permitted to get right up next to your house and peer through your window. Open fields. Courts have held that a person does not have a reasonable expectation of privacy to open fields, even if around their house, so the warrant requirement does not apply. Protective sweep. As previously mentioned, when looking for an individual, police are allowed to perform a protective sweep inside the home. They are allowed to look in any place that the person might be reasonably hiding. This would include inside a closet, but not inside of a box in the top of the closet. Once the person the police are looking for is located, the search must stop. Plain view. Pursuant to a legal entry into a building, anything that is within the officer's plain view would be considered legal to be seized if it is readily apparent on the object's fact that the object is contraband or illegal. For instance, if police are looking for a stereo, and the stereo in the home looks exactly like the one that was stolen, they would not be allowed to manipulate the stereo to look for a serial number and research the number. Wiretapping surveillance. Under the fruit of the poisonous tree doctrine, information that is obtained through an illegal search is not allowed to be used to obtain additional information. This doctrine was established by the court to restrict the temptation to conduct illegal searches simply to get one valuable piece of information. Terry stop. The Fourth Amendment protects against unreasonable searches and seizures. Generally, for a search and seizure to be valid, the officer must have a warrant. However, there are exceptions to the warrant requirement. One exception is Terry stops. Under a Terry stop, an officer may stop a suspect if they have reasonable suspicion to believe that a crime or violation has been committed or is about to be committed. They can detain the suspect for a reasonable period of time to conduct an investigatory detention to determine if a crime has, in fact, been committed or is about to be committed. Terry stops allow an officer to stop a vehicle in order to conduct an investigation into whether a crime has been committed or is about to be committed. Fruit of the poisonous tree. Under the fruit of the poisonous tree doctrine, incriminating evidence that is uncovered as a result of an unconstitutional search and seizure is subject to the exclusionary rule at trial because it is fruit from the poisonous tree, i.e. the illegal search or seizure. Reasonable expectation of privacy. Therefore, for a search and seizure to be valid, it must be reasonable. Reasonableness is determined by asking whether an individual has a reasonable expectation of privacy. This is a two-pronged test that contains an objective and a subjective element. First, was the person's expectation of privacy objectively reasonable? Specifically, would reasonably prudent person in D's circumstances have expected that they had a right to privacy? And second, did D have a subjective expectation of privacy? Specifically, did the defendant actually think that he had a right to privacy in the situation? Government conduct. In order to file a motion to suppress for unreasonable search and seizure, the defendant must have standing. There must be conduct by the government, a police offer, and in an area where the defendant had a reasonable expectation of privacy. A defendant has a reasonable expectation of privacy in their home, or in the home where they are an overnight guest. A defendant does not have a reasonable expectation of privacy in the home of another where they are not staying. Further, a defendant cannot raise the reasonable expectation of privacy of a third party. Government's actions must specifically violate her right. Motion, incompetent to proceed. If a defendant is found incompetent on the request of the defendant's attorney, the state prosecutor, or the court, the judge will stay the proceedings and order the defendant be evaluated by no more than 3, but no less than 2 mental health experts. Trusts. Valid trust. Validity of trust and enforceability. After Sally's death, to create a valid private express trust in Florida, a settlor must have I capacity. 2. Present intent to create a trust. 3. Property, or res, distributed to the trust. 4. Ascertainable beneficiaries. V. At least one trustee. And 6. A valid trust purpose. This trust seems to satisfy all such elements and is therefore a valid trust. The settlor must have the proper capacity required for the type of trust created. Florida defaults to a revocable trust unless there is clear language stating that it shall be irrevocable. An irrevocable trust will require the same capacity needed to permanently make a gift or irrevocable transfer. That is, they must understand the consequences of the instrument, awareness of what is being given and to whom, and not be under any means of duress or incapacity. Present intent requires that the settlor intended to clearly make this instrument enforceable at the time it was signed, and not at a later date. The trust must have property owned by the settlor actually transferred into its possession to be valid, unless it is a testamentary pour-over trust. A trust must have valid ascertainable beneficiaries. The trustee must be named and must be accept the role of trustee. Evidence of acceptance can be proven by their actions using the power of trustee. A trust must have a valid purpose that is not illegal or against public policy. A trust will be valid after the death of the settlor if the trust meets the requirements of a testamentary instrument such as a will. A will requires a written instrument with the testator's signature at the bottom, as well as 2 witnesses. The same requirements of no duress, incapacity, or illegal influence apply. Modification or termination of the trust without court involvement. After the death of the settlor, an irrevocable trust may in certain circumstances be modified without court involvement if all the trustees and beneficiaries unanimously agree that the trust no longer serves its material purposes. However, the trustee can deny such modification or termination if in good faith he or she believes that the trust still has a valid purpose. Judicial modification or termination of irrevocable trust. In addition to modification or termination through a trustee, beneficiaries where a settlor is deceased can seek judicial modification or termination of a trust that's purpose is materially being frustrated. The court must find that the initial purpose of the trust is not valid, not feasible, or not in the best interests of the beneficiaries based on the current situation that was not considered at the time of trust creation. The court will look to the intent of the settlor both through express trust provisions and extrinsic evidence for guidance. Grounds to remove Tom as trustee. A trustee has many duties to the beneficiaries, such as a duty of loyalty, duty to diversify assets, etc. Included in that duty of loyalty is the general standard of acting in the beneficiary's best interests. Breaches would include self-dealing, conflicts of interest, commingling funds, and failure to abide by these duties can be grounds for removal. Absent express language, beneficiaries cannot remove a trustee without cause. Trustees also have a duty to inform, which includes providing accounting of the trust to the present beneficiaries, no less than annually. Spendthrift clause. A spendthrift clause is one that prevents beneficiaries of a trust from voluntarily or involuntarily alienating their interest in a trust. This type of provision in a trust prevents a beneficiary's creditors from attaching to their interest in the trust. Exception applies to the following creditors who can attach notwithstanding a spendthrift provision: child support, alimony, government creditors/taxes. Also, a settlor cannot shield himself from his own creditors with a spendthrift provision. Discretionary trust. A provision in a trust that makes distributions discretionary is valid. The trustee has broad discretion as to when to make distributions when there is a discretionary clause. Discretionary clauses also insulate beneficiaries from creditors because they have no right to distribution. Thus, their creditors have no right to compel a trustee to distribute. Homestead exception. In Florida, homestead exemption applies to prevent creditors from attaching to the interest of an owner of homestead property. The scope of homestead protection extends to 1/2 acre of land within the municipality, including the residence only, and up to 160 contiguous acres outside the municipality, including improvements. Exceptions to the homestead protection include creditors such as mortgage on the property, mechanics liens, and property taxes. The proceeds from the sale of a homestead are also protected so long as the owner intends to reinvest in another homestead within a 16 reasonable time. Once reinvested, the surplus, if any, from the sale of homestead property is not protected. It is a general asset to which creditors may freely attach. Testamentary capacity. Turning to the requirements for all trusts, first, the capacity to create a trust requires that Sally, as the settlor, have understood the effect of the document as well as her natural bounty, because the trust is revocable. It need not meet the higher standard for capacity applicable to wills and irrevocable trusts. Trustee breach of loyalty. Regarding breach of fiduciary duty, as trustee, Ted owed two sets of duty to Ben as beneficiary, a duty of loyalty and a duty of reasonable care in the administration of trust assets. With respect to the duty of loyalty, it is a per se violation for a trustee to engage in self-dealing. Termination of a trust. A trust can be terminated when consistent with the settlor's intent. So long as the settlor is living, this may be done by consent of all the beneficiaries and the settlor. However, Sally, the settlor, is dead. When the settlor has died, the trust may be terminated by unanimous consent of the trust beneficiaries so long as doing so would not conflict with the material purpose of the trust. Among material purposes for trusts are spendthrift clauses or other clauses designed to limit the discretion of the beneficiary to dissipate trust assets. Totten trust. Money trust may also be a valid Totten trust. A Totten trust uses a bank account to deposit funds for the benefit of another beneficiary. Exculpatory clause. Exculpatory clauses in trust can relieve the trustee of liability. However, if the exculpatory clause is found to have been a result of undue influence or the clause is one that prevents the trustee from being liable for bad faith/reckless behavior, the exculpatory clause will be found invalid. Duty of good faith, impartiality, loyalty. A trustee has duties to administer the trust with good faith and in a prudent manner. He has a duty of loyalty, no self-dealing, duty of impartiality, take the needs of beneficiaries into consideration, duty to earmark trust and prevent commingling, duty to report, duty to preserve and make trust productive, and duty to act as a prudent investor. Breach of trustee, remedies. When it is found that a trustee breached his duties, the court shall award specific performance, order an injunction to prevent trustee from continuing breach, order to pay damages, or to restore property, whichever is greater. Or he shall be removed as trustee. Trust would not fail for this because court could appoint another. Trustee removal. Qualified beneficiaries, settlor or co-trustees, can ask the court to remove trustees, and the court will do so if it finds that keeping trustee is detrimental to the administration of the trust if 1. Lack of co-trustee cooperation 2. Failure or unwillingness to run/administer the trust 3. Substantial change in circumstance 4. Breach of trust duty. Charitable trust. The Attorney General, run/in charge of charitable trusts, has the power demand action from/for charitable trust. Charitable trusts are those who have ascertainable beneficiaries, usually look at the general public, and must be for a charitable purpose, furtherance of religion, education, government, health. Charitable trusts are also not subject to the rules against perpetuities, can last forever, indefinite. Honorary trust. In Florida, honorary trusts are allowed. An honorary trust may be set up for the purpose of providing for a pet once the settlor has died, or to take care of a gravesite. The statute of frauds applies to honorary trusts set up for pets, and the trust will only continue for as long as the last pet who was alive at the time of the settlor's death has also deceased. Trustee compensation. Trustees are entitled to reasonable compensation for administering a trust. The amount paid to the trustee is deducted from the trust res, 1/2 from principal and 1/2 from income. The amount of compensation can be set forth in the trust instrument. Breach by trustee, damages. They could recover the profits the trustee was making as a result of his breach. T could raise various defenses such as 1. The beneficiaries consented. 2. He was released by 2/3 of the trust beneficiaries. 3. His breach was ratified. Or 4. Reasonable reliance on the trust instrument. However, none of these defenses appear to be viable on these facts. Likely, a court would find that the fee T took was a violation of his duty of loyalty and that the beneficiaries are entitled to damages. Generally, damages for breach of the duty of loyalty are the greater of 1. Replacing the trust property to what it would have been absent the breach, or 2. Recovering the profit the trustee made from the self-dealing. Standing to challenge. Any beneficiary of a trust has standing to challenge the trust or can assert a claim that the trust must be distributed in a particular way. Trustee's duties. A trustee is required by law in Florida to avoid self-dealing, act prudently in investment decisions, and owes a duty of good faith and loyalty. A trustee who has particular experience in managing a type of asset is held to a higher standard of care than someone without such experience. In Florida, where there is more than one trustee, the trustees must make decisions jointly and are not permitted to divide up the administration of the trust among themselves without all taking an active role in trust administration. Prudent investor. The prudent trustee rule requires a trustee to invest prudently. The measure of prudence is based on the time of the investment. A trustee with special skills or expertise is held to a higher standard under this rule. Duty of loyalty. Self-dealing is present when an investor uses trust funds to benefit himself. Constructive trust. Constructive trusts are meant to equitably allocate trust property under 5 situations: theft, breach of fiduciary duty, homicide, breach of promise, and fraud. The court will consider extrinsic evidence to determine the rightful beneficiaries of the trust. Simultaneous Death Act. Extrinsic evidence to determine the rightful beneficiaries of the trust. Florida has adopted the Uniform Simultaneous Death Act, which states that if 2 people die at the same time, it is presumed for purposes of dividing their property that they survived the other. Florida has not adopted the rule that the spouse must survive the other spouse by 120 hours in order to take it out of the act. Resulting trust. Any part of this estate that fails would result back to the estate. Elective share. A spouse has a right to take an elective share upon the decedent spouse's elective estate equal to 30% of the elective estate. Property included, among other things, in an elective estate includes the settler's interest in a revocable inter vivos trust. Florida constitutional law. Florida Constitution and violated Florida's Sunshine Law. There are a number of rights that are enumerated under the Florida Constitution's Declaration of Rights, DR. Generally speaking, the DR is Florida's equivalent to the U.S. Constitution's Bill of Rights, and most, if not all, of the rights under the DR are regarded as so important/fundamental that any regulations on these rights must pass strict scrutiny review, which means that the government has the burden of proving that the regulation is narrowly tailored to achieve a compelling interest, and it is the least restrictive means of achieving that purpose. The right to open government is one rights enumerated under the DR. Open government means that citizens have the right to remain apprised of actions taken by public officials and conversations in furtherance of those actions. Further, under the Florida Sunshine Law, any meeting between 2 or more public officials in which the officials discuss their official duties and actions that will affect the public must be noticed to the public, and the public has the right to attend. The word meeting is construed broadly, although public officials are allowed to attend social functions together without running afoul of this. If the officials start discussing their official duties or actions that will affect the public pursuant to their duties, then any decisions made during those conversations will not be considered binding. Charter County Authority. A charter county has the authority to make laws for the health, safety, and welfare of their citizens, provided that the laws are not preempted by Florida state laws. A non-chartered county will only have the authority to create laws pursuant to the authority granted by the Florida legislature. Access to courts. All citizens of Florida are entitled to access the courts without denial, sale, or delay. If the law denies access to the courts in some manner, the government must provide a reasonable alternative. If the law does not provide a reasonable alternative, then the government must show that there is a public necessity and no other reasonable means of addressing that necessity. Takings. The Florida Constitution provides an even greater protection than the Fifth Amendment to the U.S. Constitution. Under the Florida Constitution, no person shall be deprived of their property without just compensation, and the government may only take their property on a showing of public necessity. Additionally, property cannot be distributed to any private entity after it is taken. This provision of the FL Constitution typically applies to issues of real property and not personal property. Standing. A citizen will have standing to challenge the search and seizure of their property if they have a reasonable expectation of privacy in the thing to be searched or seized. This provision in the FL Constitution is written in conformity with U.S. Constitution 4 Amendment. Separation of powers. The Florida Constitution provides that certain powers are delegated to each of the 3 branches of government: the legislative, judicial, and executive. Excessive bail. The Florida Constitution prohibits setting excessive bail. In fact, everyone jailed for an offense other than a capital or life felony has a right to pretrial release so long as they do not pose a risk of flight or failing to show up for their court date. They do not pose a risk to the judicial process or to the community at large. The bond condition in this ordinance requires a mandatory surety bond of $2,000 times the number of months a person was previously incarcerated, which is excessive. The bond is not related to a person's flight risk or their danger to the community. The bond requirement is also not related to a person's ability to actually post the bond. The bond would therefore result in more indigent and poor people being imprisoned than people who are not indigent or poor. The bond provision would thus violate the Florida Constitution as an excessive bond. Ex post facto clause. The ordinance punishes activity that occurred before the ordinance was enacted or before people had a reasonable chance to become aware of the requirements of the ordinance. That is, the ordinance punishes living within a certain distance of a school, with no provision that the ordinance could only be enforced for violations which occurred after the ordinance was enacted. To be properly enacted, legislation must contain a short and simple statement of its purpose, contain only one subject matter, must contain a description of the law that is easy to understand, and must contain enacting language indicated that is enacted by the Florida legislature under the authority of the state of Florida. Similar requirements may be applied to the Board of Commissioners and their ordinances. The ordinance in this case would probably meet basic requirements. Establishment Clause. The Florida Constitution provides similar protections as the federal Constitution does in this regard. The ordinance will be examined to determine whether it is directed toward religion and has a secular purpose, whether the government is entangled with religion, and whether the ordinance furthers or inhibits religion. Bond. The judiciary is responsible for setting bond and making the determination of whether someone charged with a criminal offense is entitled to bond pending trial. By setting a mandatory bond in the statute, the city infringed on the judiciary's powers in violation of the requirement that each body of government, legislative, executive, and judiciary, have separate powers that may not be infringed by the other body. Criminal infraction. Commissioners may not establish crimes. Crimes may only be declared by the state legislature. Municipalities may legislate that certain things be considered ordinance violations, but they may not be punishable by imprisonment. The fact that John was arrested while walking out of his house also weighs in favor of a finding that the punishment and bond provisions of the ordinance go beyond being merely an ordinance and have in fact legislated the creation of a new crime. Since legislating for whether something is a crime or not is a function of the legislature, this ordinance violated the Florida constitutional requirement that certain powers be exercised only by certain arms of the government. Substantive due process. When a fundamental right is implicated, strict scrutiny applies. Under strict scrutiny, the government must show that the law is necessary to further a compelling state interest. For all other rights, only rational basis review is required, under which the plaintiff must show that the law is not rationally related to any legitimate government interest. Legitimate government interests under the state's general police powers include providing for the health, safety, welfare, and morals of the people. Homeroom powers. Under homeroom powers, a municipality/county in FL can enact ordinances relating to the health, safety, welfare, and morals of the people. However, such ordinances must not violate the FL or U.S. constitutions, nor be preempted with the same. The First Amendment of the U.S. Constitution, applicable to the states through the 14th, protects the freedom of speech and association and the free movement of ideas through society. Right to keep and bear arms. Like its federal counterpart, the Florida Constitution does protect this right. Specifically, it provides that the right of the people to keep and bear arms for self-defense and defense of the lawful authority of the state shall not be infringed. But it adds that the manner of regulating the bearing of arms can be regulated. That sounds bad for this law, arguably, but the 16 courts have interpreted this provision relatively lax in practice. Specifically, they have held that guns commonly used in criminal enterprises can be banned by the legislature, that the legislature has broad authority to regulate with respect to other firearms, while suggesting that the legislature might go too far if it were to ban common firearms. Kluger test. The Florida Constitution guarantees that the courts will be open to all, without sale, denial, or delay. The Florida Supreme Court has developed the Kluger test to determine when that right has been violated. Under the Kluger test, the legislature may not close the courts by abolishing causes of action that otherwise exist unless 1. It provides a reasonable alternative, or 2. The government can show that the law serves an overriding public need that cannot be met with any other alternative. City ordinance. Cities, also known as municipalities, if incorporated, which this one seemingly is, have the right to create ordinances based on police powers and the state in general for the health, safety, welfare, and morals of Floridians. Municipalities and chartered counties can create laws that supplement the general and special laws that the state legislature has created. On the other hand, unchartered counties would not be able to do so. They are limited specifically to those general and special laws. But municipalities can create laws for the police power of protecting their citizens and will argue that this falls into it because it is specifically to fight crime and reduce juvenile crime and the consequences thereof. Local government encroachment. Article 5 spells out the jurisdiction of the courts in Florida. It states that the legislature is not empowered to endow judicial power to the executive beyond levying certain, as in specific, legal fines. The exception is that the legislature can establish a civil traffic infraction quasi-court system. When a governmental entity, a branch of government, takes some authority from what is rightly endowed in another branch, then that is considered encroachment. Encroachment by local government, like administrative entities taking on judicial functions, has been and will be considered unconstitutional. Broward County. Mayoral appointment. In local government in which quasi-legal decisions are made, like in traffic fines, it is unconstitutional for the mayor to have an intimate process in the administration. For example, it has been held unconstitutional when a mayor served as the county fines determiner and also was able to allocate that money from the fines. This governmental entwinement between the city/county's executive and the judicial system will be struck down. Sovereign immunity. Florida enacted governmental immunity in accordance with the federal government, but is liable for damage to property and people. The government is liable for injuries that are a result of operational duties, but not planning. Governor powers. The governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and in the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session, other than those for which the special session was called. FL statute formalities. First, the Act includes a short title that sufficiently describes the subject matter of the law. Second, there is an enacting clause. Finally, the purpose for the Act was likely in accordance with the legislature's authority to pass laws for the general welfare, health, safety, and morals of the public, as the purpose of the bill deals with litigation efficiency and raising revenue, though the means by which these purposes are achieved are questionable, as discussed below. However, the Act likely violates the single subject rule. To comply with the Florida Constitution, a law must cover only one subject. Each component part or aspect of a law must have some natural relation to an overall scheme. Special law. Dealing, general standard of acting. A special law, unlike a general law, is a law that only applies to particular geographic areas in a state. Special laws are permitted, so long as voters in the effective area are given notice of the proposed law and a referendum is held. Additionally, a special law, as well as a general law of local application, which does not require notice and referendum, but applies to certain areas based on a classification scheme such as population, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petty juries, conditions precedent to bringing civil or criminal claims, venue rules, and rules of evidence. Right to attorney. The invocation of the right to counsel in response to Miranda warnings is not offense-specific. This differs from the appointment of counsel under the Sixth Amendment, often at a preliminary hearing. If clearly invoked, police must cease interrogation unless the suspect reinitiates contact and waives his Miranda rights. Generally, statements asking about whether a person should get counsel are not clear invocations of the right. Inevitably discovery. When evidence would have been inevitably discovered regardless of any unlawful search, it may still be admitted. Inventory search. Officers may lawfully search vehicles when searching is a typical business practice of the law enforcement unit. Car search. If an officer has probable cause to search a vehicle, he may search any part of the vehicle that may contain evidence of that crime. An officer may not, however, search containers that could not reasonably hold the evidence, such as searching a lunchbox when the officer has probable cause to think the suspect has a bazooka. Automobile exception. The automobile exception allows certain limited searches due to the transitory nature of automobiles. Indeed, a person has less expectation of privacy in her vehicle than in her home, due to the transitory nature of vehicles. Similarly, an officer has significant concerns regarding the potential destruction of evidence should a vehicle leave the scene of a potential crime. Homestead tax exemption. In Florida, homesteads qualify for tax exemptions of $25,000 initially, plus another $25,000 for non-school ad valorem taxes for value between $50,000 to $75,000. Further, property taxes on a homestead may only be increased by the less of 3% or the Consumer Price Index. Also, it is unconstitutional for the state of Florida to tax property. The only entities that can levy ad valorem taxes are 1. School districts, 2. Counties, 3. Municipalities, and 4. Special taxing districts. Homestead creditors. Generally, homestead property is exempt from any forced sale or judgment lien. However, creditors may force a sale of a homestead if the debt is 1. A mortgage, 2. A mechanic's lien for improvements to the property, or 3. Unpaid federal or state taxes. Further, a property will not be protected from forced sale if the homestead protection came into existence after the judgments were entered or in an effort to evade creditors. However, if the creditors obtain executions against John, they may recover from proceeds of his sale. Homestead termination. In Florida, a homestead protection generally terminates on a valid devise, sale, or conveyance, but it may continue if the home is devised to the testator's spouse or children. Further, an organization or corporation may not benefit from any homestead protection. It is only for natural persons. Generally, a surviving spouse is granted a life estate in a homestead, with a vested remainder in fee simple in any minor children. Also, the rule against perpetuities does not apply to life estates and vested remainders. Vested remainders are remainders which have ascertainable grantees or must vest within a certain amount of time. Separation of power. The FL Constitution provides that the three branches, legislative, judicial, and executive, each have their separate and specific functions and cannot be directed, encroached on, or interfered with by one or both of another branch of government without specific authority designated in the FL Constitution. This is similar to the separation of powers under the U.S. Constitution, but more specific and stringent in many regards, especially in the realm of executive branch encroachment on the judicial branch, as it appears to be the case here. The governor, as part of the executive branch under this law, would be encroaching on the judicial branch's area of responsibility under the FL Constitution by becoming the appeal agency from the circuit court. Under the FL Constitution, the district courts of appeal have specific jurisdiction for appeals of circuit court judgments. The legislative branch has police powers to make law, but cannot pass legislation to become law that would require any branch to encroach on another branch for their duties set forth in the FL Constitution. Ad valorem taxes. Normally, all municipality property is exempt from ad valorem taxes. However, when deciding if the municipality property is exempt from ad valorem taxes, you must look to the government purpose v. commercial purpose test. If the land is being used for a private purpose, it is not exempt from ad valorem taxes. On the other hand, if the property is being used for a government purpose, it will be exempt from paying these taxes. Membership right. In Florida, the right to work is an enumerated right in the Florida Constitution. These rights are looked upon as fundamental rights. In Florida, one may not be granted or denied work based on their membership or non-membership to a union. Florida government bonds. In Florida, there are two types of bonds that may be issued in order to finance government projects. General obligation bonds are bonds that repayment is guaranteed by the full faith of the government. In order to pass a general obligation bond, there must be a referendum by the people on whether it may issue. Things such as schools and bridges require no such vote. Revenue bonds are bonds that are paid back from the revenue that the project generates. Municipalities may issue a bond without a vote if it matures within 1 year. General laws/special laws. In order for the legislature to pass a law, it must be passed in a legislative session. Laws must have a title that gives notice and is not confusing, contain a single subject, and must contain an enabling clause that reads, "Be it enacted by the legislature of the state of Florida." General laws are laws that cover everyone in the state even-handedly and only require passage of the Florida legislature. A special law is one that applies to only a certain person or groups of persons or a certain geographic area, such as a city. Special laws require either notice before the passing or a referendum after the passing, or the law will have no effect. General laws of application are laws that are general laws that apply uniformly to an area, such as one that has a minimum or maximum population requirement. A bill of attainder. A bill of attainder is legislation that attempts to impose a punishment on someone without the benefit of a judicial determination. Family law. Modification of time sharing. In Florida, the default time-sharing setup is an equal sharing of time, since it is presumed that parents should equally share the joys, responsibilities, and rights of raising a child. This default can be deviated from when that would be in the best interests of the child, i.e., equal time sharing would be detrimental, or the parties agree to it. As the parties' agreement can be adopted into a dissolution of marriage order as it was here. When a dissolution of marriage order includes provisions regarding time-sharing, those provisions may be modified upon a showing of a substantial change in circumstances from the time when the order was entered. Modification of child support. Like with time-sharing, modification of child support also requires showing a substantial change in circumstances. A change in income that would lead to a 15% or $50 increase in child support obligations is typically found to be a substantial change in circumstances. If mother is correct and father's income has nearly tripled, a 15% or $50 increase would likely be found, and the court would likely grant modification of the child support order to have father pay more child support. Notably, child support is intended to put a child in a position to receive the same split/amount of resources from the parents as the child would if the parents had remained married. A goal which would be met by increasing the child support father must pay if his income has come anywhere close to tripling. The beneficiary of child support is the child, so parents may not waive child support on a child's behalf nor agree to a reduction below the amount to which a child is entitled. The anti-modification clause would result in the latter, since it would prohibit child support from being increased to be congruent with child's needs and best interests. Modification of alimony. As an initial matter, unlike child support, alimony is a spouse's benefit to waive, so the clause prohibiting modification may be enforceable to prevent mother from modifying alimony. Such a clause may be enforceable if it is reasonable and agreed to by both 20 parties, both of which appear to have been here. If the anti-modification provision is not enforced, mother may be able to modify alimony if she can show a substantial change in circumstances has occurred since the order set the alimony. Since alimony is largely based on a balance between the payee spouse's need and the payer spouse's ability to pay, father's alleged large increase in income would qualify as a substantial change in circumstances. Alimony. In Florida, there are a few types of alimony, including pendant light, alimony during the divorce proceedings, rehabilitative, alimony to allow the spouse support while renewing any necessary licenses or work skills needed to support themselves, bridge the gap, alimony to allow time for the spouse to transition from being married with financial support to being single and self-supporting, durational, alimony to allow for support for a specified period of time, permanent, alimony for the duration of one's life, or, typically, 8 until the receiving spouse marries or lives with a supporting partner. When alimony is determined, it is based on a need and ability. In determining if the court should award alimony, the court will look to the party's need for financial support and the other party's ability to pay the same. The court would further look towards the length of the marriage. A marriage of less than 7 years is considered a short-term marriage, a marriage of 7 to 17 years is considered a mid-length marriage, and a marriage of longer than 17 years is considered a long-term marriage. Typically, duration alimony and permanent alimony will not be awarded for a short-term marriage unless there are exceptional circumstances. A mid-term marriage may be eligible for all but permanent marriage, depending on the circumstances, unless exceptional circumstances apply. Durational alimony, rehabilitative alimony, and bridge the cap alimony will have a set end time. Rehabilitative alimony will require the party in need to have goals and expected deadlines in which to accomplish those goals, and that will help the court determine the length, not to exceed 2 years, of the alimony. Premarital agreements. Premarital agreements are essentially a contract between the parties regarding how a divorce will be handled. A contract may be oral unless it is for certain things that fall under the statute of frauds. Marriage agreements do fall under the statute of frauds, which means it will need to be written. The writing will need the essential terms, the parties, and a signature of the party to be charged. A premarital agreement may contain any agreement the parties choose as long as the agreements are legal. The agreements will be invalid if made under duress or fraud. Further, child support cannot be waived as it belongs to the child, not the parent. Alimony may be waived, but the court will not allow this waiver if it will act to put the spouse in need on state welfare. Child custody and support. When two parties have children in common, the court will determine, if the parties cannot agree, legal and physical custody. Legal custody generally starts at joint legal custody and will only be changed if the judge finds it to be in the best interest of the child. Physical custody will come with a parenting plan to ensure the parents each have access to raise and care for their child. The physical custody and the parenting plan, if not agreed upon by the parties, will be determined by the court using the best interest of the child factors. The court enjoys broad discretion over these matters, and the order will not be overturned on appeal unless there's a showing of abuse of discretion. The appeals courts shy away from overturning family law orders because the presiding judge will best be able to determine the relevant factors as they see the parties in person and know their local area and needs best. Child support will be determined based on state guidelines. Any deviation from the guidelines by more than 5% will require the judge to show finding to support the deviation. Equitable distribution. Florida follows an equitable distribution framework. This does not always mean equal. The court will do its best, if the parties cannot agree, to equitably distribute all marital assets and return non-marital assets to the party who owned them when entering the marriage. Marital assets include any asset the couple obtained together, or assets one spouse obtained during the marriage. Exceptions apply, such as a non-marital gift or assets devised to one spouse only. Typically, any assets brought into the marriage will be distributed back out to the spouse who entered with that asset. Some exceptions apply. For example, if a spouse comes into the marriage with a house and the house is improved during the marriage or used as the marital home, this will likely be distributed equally among the parties. At the very least, the court will distribute any increase in value equally among the parties. A further consideration to be made here is Florida's Homestead Act. Any property that is used as your primary residence will be protected up to 160 acres of contiguous land, if outside of a municipality, and any home on that land or up to 1 acre of land and home if it is in a municipality. Under the Homestead Act, not only are the parties protected from certain creditors, with exceptions, the parties are protected from the spouse selling the home without the other spouse's permission. This right can be waived in a premarital agreement. Termination of parental rights. Termination of parental rights is considered a serious action and will be presided by a judge and fully adjudicated, even though it is a civil proceeding. The circuit court will have exclusive jurisdiction over such proceedings. Parents facing a TPR are protected by the Due Process Clause of the United States Constitution and by Florida Constitution. The U.S. Constitution guarantees parents facing a TPR the right to counsel, goes beyond statutory right under Florida. Further, the government must prove its case in a TPR by clear and convincing evidence. This is a higher standard than the preponderance of the evidence standard required during shelter and dependency proceedings. During a TPR proceeding, notice must be given to parents, to grandparents, to guardians, and to any other that has possible custody rights to the children. If the state effectively files a TPR petition, that parent's rights will no longer exist, and in the face of the law that parent will have no legal relationship to that child. TPR is an individual process, and as such each parent is independent of each other. Filing of termination of parental rights. A TPR may be filed at any time. However, in Florida, DCF must file a TPR when 1. Parent has been under a case plan for more than 12 months and not met the requirements. 2. The children have been dependent for 12 months out of the last 22 months. 3. When parent has killed or attempted kill other parent or children. 4. When parent has been sentenced to incarceration, which will last through the substantial part of the child's youth. 5. Parent has failed to comply substantially with case plan. And 6. When it finds that there is good cause for initiating the proceeding. TPR can occur because a parent has abandoned the child, for abuse, for neglect, but this must be shown by preponderance of evidence. Adoption. After Obergefell legalized same-sex marriage, same-sex couples became entitled to many of the same fundamental rights as heterosexual married couples, such as the right to marriage, divorce, and adoption. Even before same-sex marriage was legalized, same-sex couples were entitled to legally adopt a child. In determining whether a person is able to adopt a child, the court looks at the fitness of the person to be a parent, her home environment, her work schedule, her ability to provide for the child, and many other factors. Adoptions may be granted for married couples or single parents. When a person/family applies to adopt a child, the state conducts a background check on all members of the household who are aged 12 or older. After the background check comes back clear, the state then interviews the parents-to-be and conducts a home study to ensure a safe environment for the child. Following a successful home study, the parents wait until a child is placed with them. The child is placed with them for a period of time, generally around 6 months or longer, to ensure the match is a success. This time is called adoptive placement, and during this time the parents-to-be and the child make sure that everyone is happy with the placement. The state makes routine checks on the child to ensure everything is going well. Finally, once the placement seems appropriate, the parents-to-be may petition for the adoption to be finalized. The judge generally grants this petition in chambers, so long as it is clear that the adoption is in the best interests of the child. Time sharing. Time sharing must also be awarded in the parenting plan. This includes overnight and holiday visitation, and it is also awarded based on the best interest of the 7 children. The court starts from the position that each parent should get 50-50 time sharing with the children, unless it has reason to award more or less time to one parent. There are no presumptions that either mother or father are better suited to have primary time sharing. The court will look at factors such as the age of the children, the desire of the children, if they are old enough to express it, the fact that the mother has been the primary caretaker of the children, whether the father's work schedule will interfere with his ability to enjoy time sharing with the children, and any other factor the court deems necessary to support the best interest of the children. Child support. Child support is calculated irrespective of time sharing and parental responsibility. Whether or not a parent enjoys time sharing or parental responsibility, they are still responsible for supporting their children. Child support calculations are based on statutory guidelines. The amount is based on the net income of the parties, the number of children, and the amount of time sharing each parent enjoys. The court may deviate upward or downward from the guidelines by 5%. A greater deviation would have to be supported by written findings. A parent that enjoys 20% or more overnight time sharing will also be able to get a reduction in child support. In addition to making a child support calculation, the court will have to indicate in the parenting plan which parent will be responsible for providing health care coverage for the children and how uncovered medical expenses and other out-of-pocket expenses will be divided. Custody/parent planning. In Florida, the court develops what is known as a parenting plan. This plan includes 2 portions: 1, time sharing, and 2, parental responsibility. There is a presumption that the child should spend equal time with each parent. However, the superseding factor is always what is in the best interest of the child. Under a time-sharing plan, both parents should have equal time with each parent. However, certain factors may come into play, such as who raised the children, where they go to school, where they want to stay, if they are at an age where they could understand such a decision. There are many other factors in making this determination. The second prong, parental responsibility, includes 2 types: ultimate responsibility and parallel parenting. Under ultimate responsibility, each spouse is solely responsible for a certain responsibility, i.e. schooling or medical. Under parallel parenting, those responsibilities are shared. Relocate with kids. If one spouse intends to move more than 50 miles away, he or she bears the initial burden of proof. She must show that based on numerous factors, such as job opportunity, child's choice, depending on age, and other such factors. If moving, the moving spouse must provide the new address, how time sharing will continue to work, among other requirements. The burden then shifts to the opposing spouse to show why the move would be improper. Life insurance. Life insurance policies are essentially will substituted, which terminate by law upon divorce. Jurisdiction. In order for a party to file this type of action in a Florida court, the party has to be living in the state for at least 6 months. In order for the court to have personal jurisdiction over the opposing party being served, the party must either be a resident of the state, or there must be a basis for personal jurisdiction pursuant to Florida's long-arm statute. Florida's long-arm statute analyzes the party's contracts in the state, for example, whether the party owns property or does sufficient business in the state. When an action involves a child, jurisdiction will be based upon the Uniform Child Custody Jurisdiction Enforcement Act, UCCJA. The state that issued the first order regarding the child will always have continuing jurisdiction to modify it. However, jurisdiction could also be established in the state where the child and at least one parent have resided for the last 6 months. If this cannot be established, Florida could still take jurisdiction if no other state wanted to take jurisdiction of the case. Bank account. The money that is held in the savings account is in both names and presumed to be held in TB. Therefore, without some reason for its protection, the money may be garnished by the judgment creditor. However, In Florida, wages of the head of household are exempt from garnishment for 6 months after they are received, even if placed in a bank. If the funds are commingled, they lose their protection to the extent they cannot be traced. Therefore, one of the parties would have a right to claim exempt the money that could be traced to their wages if they so claim after a writ of garnishment 9 is issued, and they can establish that they're the head of household, which requires a showing of providing 50% or more support to a dependent, the other spouse in this instance. Additionally, in Florida, homestead exemptions, not real property, include a $1,000 exemption for personal property. Therefore, they may claim this exemption as well. Money market account. The money market account was also titled jointly. Again, this creates a presumption that it belongs to both parties of the marriage. Marriage debts. In Florida, any debts or assets acquired after a petition for dissolution of marriage is filed is considered the sole debt or asset of the person acquiring it. Parent consent. As to daughter, uncle needs both the husband's consent and the daughter's consent because she is over the age of 12. Regardless of her age though, Florida does not have an age at which children have the absolute right to consent to family law proceedings. Grandparents' rights. Florida gives protections to grandparents. Grandparents here would have a right to receive notice of the TPR proceedings. They also would have rights to challenge an adoption by the uncle. They have preference rights, such that they might have a better case for being assigned custody of the children. In Florida, grandparents would also be entitled to visitation rights to the children while in the mother's care, and if put into custody in anyone else's care. Please choose as long as the agreements are legal. The agreements will be invalid if made under duress or fraud. Further, child support cannot be waived as it belongs to the child, not the parent. Alimony may be waived, but the court will not allow this waiver if it will act to put the spouse in need on state welfare. Ethics. Conflict of interest. A lawyer has the duty to provide diligent and competent representation to its clients. Part of providing diligent representation is avoiding conflicts with former, prospective, or current clients. A conflict exists when representing one client would impede effective representation of another client, or would involve the disclosure of confidential information that must be protected. Normally, a lawyer cannot provide representation to a prospective client concerning the same or a substantially related matter in which that lawyer represents a former or current client with adverse interests. Within a firm setting, a conflict that one lawyer has in a firm is imputed to the other lawyers working at the firm. Therefore, the fact that another lawyer in the firm represented Chipco would be imputable to other lawyers in the firm. If a conflict does exist, then a firm may still provide representation if 1. Diligent and competent representation can be provided to both affected clients. 2. The representation does not involve representing both clients with adverse interests to one another in the same proceeding before a tribunal. And 3. Both clients provide their written and informed consent. Conflict of interest screening. Additionally, the adverse party to the litigation, manufacturer, is a client of the firm in another office. However, that partner's disqualification will be imputed to the entire firm. Normally, an imputed conflict may be avoided if the lawyer avoids more exposure to the information than necessary, is timely screened from the matter, and does not share in the fee. However, even if they were to screen the other attorney, this particular representation would require asserting a position in court that is directly adverse to the other client, retailer versus manufacturer. As a result, Larry lawyer should decline representation of retailer owner. Attorney advertisement. The Florida Rules of Professional Responsibility states that advertisements must contain a disclosure in red that it is an advertisement on the envelope and first page. The ad cannot guarantee results or make misrepresentations. Referral fee. The RPC forbids mere referral fees. Fee sharing is okay, as long as there is proper division of fees with the other lawyer, there is an agreement with the client setting out the joint representation, and the agreement sets out the proportionate share and division of the work. Both attorneys must be jointly and severally liable to the client and be equally available to the client, and the fee must be reasonable. Duty of confidentiality. A lawyer's duty of confidentiality extends to all information obtained in the course of representation and may not be breached. It extends indefinitely. Communication with a judge. It is unethical for an attorney to paint the picture that an attorney may exercise any kind of undue influence over a judge in a matter, whether that be through personal influence or threats or anything else. Judges must remain entirely impartial in the cases they handle. It is also impermissible to capitalize upon personal relationships a party may have with a judge in order to further their case. Ex parte communication. Additionally, in a pending matter, communicating with the judge assigned to the case without opposing counsel present for the conversation, when that communication is about the case, is an impermissible ex parte communication. Any conversations between attorney and the judge in this case, without opposing counsel present for the conversation, would be an impermissible ex parte communication. Duty of professionalism. Firstly, attorneys have the obligation to be truth, honest, and fair to opposing counsel and opposing parties as clearly set forth in the Florida Rules of Professional Conduct and the preamble to the rules themselves. To opposing counsel, I declare civility. Moreover, an attorney has an affirmative obligation under the rules to refrain from making frivolous arguments. Frivolous arguments are those in which there is no basis in either fact or law for the argument, and the argument is not made in good faith for the alteration, extension, reversal, or modification of existing law. Arguments made solely for the purpose of delay are obviously frivolous. Lastly, an attorney should not undertake a course of action solely calculated to embarrass or harass another. Reasonable fees. Fee agreements must always be reasonable. When contingencies are involved, they must be in writing. Further, any agreement to share money with another law firm must be in writing, signed by the client, stating the terms of the arrangement, and in most cases making the parties jointly or severally liable, or defining the arrangement by the amount of work done. Legal obligation to report. In Florida, all citizens have a duty to report suspected cases of child abuse by using the Child Abuse Hotline. However, certain individuals have a higher standard of mandatory reporting. This includes teachers, social service workers, doctors. It can also include professionals who are involved with the children through activities and who the children might confide in. When persons with a statutory or professional duty fail to report abuse, they may face sanctions and punishment. The general citizen, however, though under a duty, will not face the same penalties and sanctions. Attorney obligation to report. Attorneys can be held to mandatory reporting standard depending on their role. If the attorney is representing the children or in some role that would have him owe a special duty, attorney will likely be a mandatory reporter. However, in his relationship with uncle, attorney must balance his duty of confidentiality to uncle and duty to report. The duty of confidentiality runs to both actual and prospective clients if attorney has met with client to possible establish a permanent representation. The duty is broader than the attorney-client privilege, which applies to communications between the attorney for purposes of representation/litigation. The duty of confidentiality survives the death of the client. However, Florida's Rules of Professional Conduct, RPC, do allow for an attorney to break his duty of confidentiality in certain situations. It is mandatory in order to prevent a crime or bodily harm the attorney knows the client is going to commit. It is permissive when the attorney believes it is necessary in order to obey the RPC to prevent substantial harm that is likely to be committed when the attorney is defending himself against charge from the client. Contingent fee/legal services. An attorney must charge a fair fee for his or her services based upon the complexity of the case, the amount of time it will take, what other similar attorneys charge, the attorney's experience, etc. An excessive fee is one that a reasonable attorney would look down upon. Contingency fees are permitted in civil cases except for domestic matters like alimony and child support. Contingency fees are not permitted in criminal cases. Competency. When a lawyer is representing a client, and after the lawyer passes the bar, they are presumed to have a certain competency level. A lawyer can become competent in an area through study or working with another lawyer in the area of law. Solicitation. An attorney may not solicit a person with whom the attorney does not have a pre-existing relationship for his personal financial gain. In tort actions, which may be present here between Sam and broker, an attorney may not solicit an injured party within 30 days of the injury. Pecuniary interest in the litigation. Under the Florida Rules of Professional Conduct, a lawyer may not have a pecuniary interest in the litigation. Duty of candor. An attorney must avoid any conflict between his duty of candor to the tribunal and his duty of confidentiality to a client. Business transaction with a client. An attorney can enter into business transactions with a client only when they have fully disclosed their intentions and the terms of the transaction are fair and reasonable, and the attorney has advised the client to seek advice from outside counsel. Additionally, an attorney cannot create an instrument in which they will be a substantial beneficiary of and cannot accept any gifts for doing so. Frivolous claim. An attorney may not file a frivolous claim that has no legal basis. Withdraw. An attorney cannot represent and must withdraw if a client is using the lawyer to commit a crime. The lawyer could not represent A if A were using the lawyer to commit perjury. In such a case, the lawyer either cannot take the case or, if he already has, must try to withdraw. If he cannot withdraw, he must disclose the perjury to the court. If the client is committing the crime without the lawyer's services, the lawyer is not required to withdraw, but may unless the court orders her not to. Commingling funds. Attorneys are prohibited from commingling their personal funds with funds belonging to clients, funds in the trust account. Exception. Attorneys may place enough of their own funds in their trust account to cover small bank fees. Attorneys are prohibited from allowing overdraft protection on their trust accounts. Representing two parties. Under the FL Rules of Professional Conduct, an attorney who is representing two clients in the same transaction can only do it if client's interest is not materially adverse to each other and attorney reasonably believes attorney can offer diligent and adequate representation to each party. And it can't be prohibited by law. For an attorney to represent both parties, they must give both parties informed consent, meaning disclosing all material facts, and have each client agree to the representation in writing. Acquiring an interest in the litigation. The FRPC states that a party must not acquire a property interest in the subject matter of the litigation. If I were to accept the payment of 15% of any assets awarded to W, this would be considered acquiring a property interest in the subject matter of the litigation.